This is a press statement on the impasse between county governments and KPLC, and also the remarks made against county governments' share of the road maintenance levy fund by members of the National Assembly. We just are asking KPLC to exercise wisdom in the resolution of its dispute. KPLC offers critical services, but they also receive critical services from county governments, as was demonstrated by Nairobi County. It should never have escalated to that, but it can be that they bully county governments and threaten and endanger the lives of even patients in hospital. And then, when the roles reverse, they play victim. KPLC must respect county governments as governments that offer critical services. On this issue of the roads money, we don't want to throw tantrums like we saw yesterday in the National Assembly, because I describe that as throwing tantrums. All we're asking is, let's obey the Constitution of Kenya. That's all. This is a matter of constitutionalism. It cannot be wished away by throwing tantrums and insulting governors. No. And you speak in the National Assembly, we are here with the masses. We'll speak in the villages. You insult us there, we will tell the public the true position here in the village. If you think you have a platform on the floor of the house, we have a platform with the masses. We're here. The Constitution of Kenya is very clear. There are only two types of roads: national government trunk roads and county roads. Kera and Kura pre-existed the Constitution of Kenya 2010. They should have been restructured or gotten rid of to respect and abide by the Constitution of Kenya 2010. And members of parliament cannot wish away the question of separation of powers. The constituency is not a level of government recognized by the Constitution of Kenya. The Constitution of Kenya recognizes only two levels of government. And even if as Council of Governors we don't raise these questions, they are already been raised by Kenyans of goodwill in courts about the legality of the legislative arm undertaking an executive role and implementing projects. This is the crux of the matter. And no amount of insulting governors will resolve that constitutional matter. It can only be resolved in the courts of law that are there to interpret the Constitution for us. So threatening us with withholding funds and threatening us with changing the Constitution, okay, fine, let's go to Kenyans and put the question to a referendum. We have no problem with that. But for as long as the Constitution dictates what it dictates today, all we're asking is, can we then comply? Because we are a country of rule of laws. We abide by the rule of law. And for those saying in the National Assembly that they have done more through CDF or national government than the counties, the public are on the ground and they know. The public know. The public know. And I know certain MPs, by virtue of their longevity and the aura around them, probably are able to extract more from national government than others. And this is part of the problem, that a single MP can go and get money for roads in his constituency more than what the county government Ministry of Roads can avail through its budget. Yet the next MP has nothing. We can't run this country on the basis of who can get a little more from parastatols than the other neighboring MP. No, we can't run government like that. This is why there is two levels of government. Resources are to follow functions. The functions at national level are oversighted by the National Assembly. The ones at the county oversighted by the County Assembly at tier 1, and the Senate at tier 2. This is the law. This is the Constitution. So someone should not boast to us that he has done more for his constituency through national government. And in any case, we are ready for the benchmarking. Let Kenyans come, because the benchmarking that was referred to was in Wajir County. Let them come, and we take them round, and we show them what hospitals we've done, what roads we've done. You all know what this town was like before devolution. And you all know how many kilometers of tarmac this county government has done in this town. So, telling lies to Kenyans and who are not there, and yet your people are here on the ground, they know what's going on, doesn't solve anything. But let me not get personal. I want to leave it at that. On this County Additional Allocations Act, there was a mediation process which collapsed. And now we see there's two bills, one initiated by Senate and one initiated by the National Assembly. But requiring us to come out of court on RMLF in order to process the county government's allocation will not happen. We will not be blackmailed as a Council of Governors. We will not be intimidated. We will not be blackmailed. We are not coming out of court on RMLF. You can take that to the bank. I talked to you as the chair of council. We will not, unless the matter is dealt with and resolved. And we try to deal with it before going to court. We met with the National Assembly Budget and Appropriation Committee. We had a gentleman's agreement. We had gone to court first. We came out of that court on the basis of that gentleman's agreement. They reneged on it. We went back to court. And if we don't get justice, we will go back to court. And no one can deny us the right to go back to court. No. And no one will intimidate us to come out of court. No. No one is going to hold us ransom. We will not accept it. Yeah. Members of the press, citizens of Kenya, the Council of Governors' attention is drawn to two critical issues affecting counties, which are the impasse between county governments and the Kenya Power and Lighting Company KPLC, and two, remarks made against county government's share of the Road Maintenance Levy Fund RMLF by members of the National Assembly. We address you as follows on these matters. On KPLC engagements with counties, we note with great concern the ongoing impasse between Nairobi County, and the Kenya Power and Lighting Company KPLC, which has persisted for several days. While it's unfortunate that the situation has escalated to this extent, it is crucial to highlight the long-standing issue. For a decade, KPLC has wielded unchecked power over counties and other entities, often resorting to abrupt power disconnections without due process or consideration or regard of the broader impact. KPLC has a well-documented history of disconnecting power to critical county institutions, including hospitals, water installations, and sewerage services. severely disrupting operations and endangering lives. However, when the roles are reversed, the company swiftly assumes the position of a victim. This selective application of authority raises serious concerns about fairness and accountability. As a matter of fact, when KPLC switches off power from the county infrastructure, counties are unable to provide service, which also benefits them. Below, I highlight some of the historical cases of power disconnections by KPLC to county facilities. Kisumu County in 2014, power was disconnected, putting lives at risk. The then director, Dr. Ojwang, protested the move, the director of health for Kisumu at the time, but his pleas were ignored. Again, Kisumu County offices in 2019, operations were disrupted when KPLC disconnected power. In Kilifi County, the Kilifi Civil Registration Office was disconnected in July 2023. This facility, which serves over 300 people daily, remained without power for 2 weeks due to a KPLC disconnection. 4. In Mombasa, at the Mombasa General Hospital, power was disconnected in March 2023. Power was cut for several days, endangering the lives of patients. 5. In Homa Bay Town, in Homa Bay County, the town's water intake was also disconnected in 2023. Residents went without water for days after KPLC disconnected water. In Migori County, at the Migori County facilities, in September 2023, power was disconnected, leaving thousands of patients vulnerable. In Busia County, on numerous occasions, government services at the county level were paralyzed. And these are just but a few. KPLC's actions have not affected counties only, but have also affected private individuals and businesses. For instance, in 2018, a Nairobi resident sued KPLC for billing him $616,000 for 2 months, despite being away from home that period. In 2018, the High Court barred KPLC from inflating consumer bills following a petition filed by lawyer Apollo Mboya. In 2021, a hotel sued KPLC after its monthly electricity bill. In 2021, a hotel sued KPLC after its monthly electricity bill jumped from shillings 30,000 to a staggering 2.6 million shillings. That's for a month's bill. In 2023, the World Bank faulted KPLC for failing to compensate landowners for way leaves despite using their private and company land. In 2024, Professor Alfred Omenya raised concerns after receiving a Kenya shillings 2.1 million bill for a new power connection. Despite all this, KPLC owes county governments land rates in the form of contribution in lieu of rates or silo. They also owe us way leave charges, huge water bills, and other levies to the tune of billions of shillings since the inception of devolution. Additionally, KPLC continues to disregard the advisory from the Attorney General and the provisions of Section 57 of the Physical and Land Use Planning Act 2019, which stipulates that a person shall not carry out development within a county without development permission granted by the respective county executive member in charge of land use planning. The standoff that has been witnessed has merely exposed a fraction of the distress that countless Kenyans and institutions have endured for years due to abrupt disconnections by KPLC. We condemn these perennial disruptions and call for a structured approach to dispute resolution between KPLC and its consumers, ensuring that essential services are never jeopardized in the future. It is time for KPLC to reflect on its actions, acknowledge the suffering caused by its practices, and work towards a fair, transparent, and predictable billing and disconnection process. To ensure that we address the issue in the energy sector, the Council of Governors communicated with the Ministry of Energy and Petroleum via a correspondence to raise the aforementioned issues. In this regard, we urge KPLC to utilize the existing intergovernmental mechanisms to resolve any disputes with the county governments, including the issue of settlement of debt.